Hello, everyone, and welcome to today's webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. My name is GB Satusa, and I'll be your host for today's important discussion: National Interest Waiver versus Employer Sponsorship. Which EB-2 option fits you? Now, the EB-2 category offers a valuable pathway to a green card for many highly skilled professionals seeking permanent residence in the United States. However, one of the most common questions applicants face is whether they should pursue a traditional employer based sponsorship, EB-2 petition, or explore the national interest waiver option. While both pathways fall under the EB-2 category, they involve very different requirements, strategies, and long term considerations. Understanding how USCIS evaluates these cases and knowing which option aligns best with your qualifications and career goals can help applicants make more informed decisions about their immigration journey. To help us break this down, we're honored to be joined by attorney Sonyu Lau, an experienced immigration attorney who assists professionals, researchers, entrepreneurs, and employers with employment based immigration matters, including EB-2 petitions and national interest waiver cases. Attorney Lau, thank you so much for joining us today. We're excited to have you for this important discussion.
Thanks for having me. Happy to be here.
Now, before we begin, a quick reminder to our audience: immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you're joining us on Facebook, YouTube, LinkedIn, or any other platform, welcome. Please do subscribe and share this session with anyone who may benefit from understanding the EB-2 immigration process. Attorney Lau, let's dive right in. Now, to begin, can you explain the difference between a traditional employer sponsored EB-2 petition and an EB-2 national interest waiver?
The essential difference between employer-sponsored EB-2 or the perm-based EB-2 and the national interest waiver EB-2 is, with the employer-sponsored EB-2, the employer will have to do the market test or the labor certification process before they can file the immigrant petition. And in any case, you would need the employer sponsor to be able to file that immigrant petition. However, in the case of a national interest waiver, first of all, you can self-petition. You do not need any employer sponsorship. You can self-petition. And the most important part of it is you do not need a certified labor certification, meaning you do not have to go through the labor certification process. That's a huge difference between people who are exploring options to get a green card in the US.
Yeah. Now, attorney, what types of applicants would you say are best suited for each pathway?
In general, since both are EB-2, the general requirement would be either a graduate degree or, in the alternative, a bachelor's degree plus 5 years of work experience.
Yeah.
However, in case of national interest waiver, there would be a certain other additional requirement under the matter of Danasar. Under the matter of Danasar, in addition to being qualified that basic eligibility test, meaning having a graduate degree or, in the alternative, bachelor's plus 5 years of experience, you also have to prove 3 prongs of the matter of Danasar. What are those 3 prongs? Number one, that the proposed endeavor should have substantial merit and national importance. Number 2, the applicant should be in a position to advance that proposed endeavor. Number 3, on balance, the labor certification requirement should be waived at the discretion of USCIS. So that's the main difference.
All right. Now, when a client may qualify for both options, how do you determine which route makes the most sense?
And it's a great question. And most of my discussion when I do these kind of consults is around this question. For example, if somebody already has an EB-2 employer-based immigrant petition approved and they are from countries such as India and China, they cannot get a green card at this time because the dates are backlogged. So my normal question I get is, should people in those situations pursue the NIW path even though they already have an I-140 employer-based, employer-sponsored petition approved? My normal answer is yes, because with NIW, in future, when your date becomes current, you don't have to rely on the employer who sponsored you for I-140. So in addition, you can pursue both this petition at the same time parallelly.
All right.
So many people miss that, but if you think that you have some kind of endeavor that you can pursue your NIW petition, even though you already have an approved petition through your employer, my normal recommendation is yes, you should pursue NIW in that case also.
All right. Now, attorney, what does USCIS consider when evaluating whether a proposed endeavor has national importance?
So the bar has increased a lot in last 1 to 2 years, meaning your proposed endeavor should be, in a very plain language, benefiting the US. How? Your proposed endeavor maybe can show that it will create jobs for US workers. The proposed endeavor can show that it will benefit United States industries or population in general. So unless and until your proposed endeavor shows some kind of benefits to the US, the case may not get approved.
All right. Now, on the employer-sponsored side, what are the new developments affecting perm labor certification and EB-2 processing?
The major problem that we are seeing at this point, the increased adjudication time for labor certification. Meaning, if an employer comes to us right now and they want to sponsor an employee for a EB-2, the processing time can easily take more than 2 years because the process requires 3 steps. First step, filing prevailing wage determination. At this time, taking on an average 4 to 6 months to get those requests back from US Department of Labor. Once we have that, the employer has to do the recruitment, publish ads, etc., and then the employer wait for 30 days and then file the labor certification. At this time, labor certification approval is taking approximately more than 16 months. And if you get in some kind of audit from Department of Labor, the process may take lengthier than that. Once that is approved, then you file the I-140. So the entire process can easily take more than 2 years. So that's a big challenge.
Yeah. Now, attorney, what are some common challenges that arise during the perm and employer-sponsored EB-2 process?
The important challenge that we normally see is at the time of recruitment process. When the employer is conducting recruitment, they are publishing ads, inviting candidates to apply at their open position. If the qualified person applies to those jobs, then you have to stop that labor certification process. The process will not go further, and that's the end of the process, meaning the employer cannot further sponsor that person for a green card.
All right. Thank you so much for this insights, Attorney Lal. For everyone watching, today's discussion is not about identifying a single best immigration strategy, but it's rather about understanding the differences between the two essential EB-2 pathways. Every applicant's background, professional accomplishments, and long-term goals are unique, which is why understanding the advantages and challenges of each option can be so valuable. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration related questions at no cost and engage with participating attorneys. Now, Attorney Lal, based on your experience, how does ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
I think it's a great platform for people who are looking for immigration attorneys. It is also a great platform for immigration attorneys who want to have more clients for their firm. So it's a great platform connecting both the parties.
Thank you so much for those thoughts, attorney. Before we move into our live Q&A session, let's tackle this important question. What is one common misconception applicants have about choosing between an EB-2 national interest waiver and an employer-sponsored EB-2 petition that you believe should be clarified early on in the process?
Many people think that you cannot pursue both these applications at the same time. You can pursue both these applications at the same time. It benefits specifically people who are from backlog countries such as India and China,
Yeah.
because their wait time to eventually get their green card is a lot longer. And
Yeah.
in that time frame, a lot of things can happen. You might want to change employer, etc., etc. So you can, if you have the option, you should pursue both those petitions, employer-based EB-2 and then the NIW EB-2.
All right. If you're just joining us, we've been speaking with attorney Sonyu Lal on national interest waiver versus employer sponsorship. Which EB2 option fits you? We're now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. We're also proud to share that immigrationquestion.com is triple B accredited and ISO certified. This reflects our commitment to transparency, accountability, community education, and security. Please drop those questions in the chat or call us live at 516-703-3483, and we'll take as many as time permits. All right. Adibimpe is asking, should I pursue an EB2 NIW now or wait for my employer to sponsor me through the perm process?
Well, this is the exact point I mentioned. If you can pursue both the options, pursue both the options. You need not wait either of those, what's going on. If you can pursue both, I would recommend pursue both,
All right.
especially if you are from a backlog country.
Yeah.
If your priority dates are current, then probably either is fine. But if you are specifically from a backlog country, you should pursue both.
All right. Santiago is asking, which option is actually faster in 2026? An NIW petition for an employer-sponsored EB2 case,
It's a very
NIW
good question.
or
It's a
an
very good question
employer-sponsored
and
EB2
very
case?
relevant one also. So definitely in terms of timeline, the NIW petition is shorter. Why? Because there is no labor certification requirement with NIW. Because the employer-based EB2 would require the labor certification process, which, as I mentioned, it's taking more than 16 months as of now. So definitely, in terms of faster processing, NIW petition, specifically when it is filed with premium processing service.
All right. Rohan is asking, how do I know if my work is important enough to qualify for a national interest waiver?
It's a good question. If you are exploring NIW option, I would recommend speak to a qualified immigration attorney who can probably review your initial proposed endeavor and guide you further. But in general, if your proposed endeavor is able to create jobs in the US, is able to help US industries, either manufacturing or other industries, then you can argue that your proposed endeavor will be in national interest.
All right. Mirel is asking, has USCIS become stricter with NIW approvals in 2026?
Well, that is unfortunately true. If you look at USCIS own data, you can see that the approval rate for NIW in the last 1 to 2 years has gone down dramatically.
Yeah.
So yes, it has become stricter and stricter.
All right. Takumi is asking, can entrepreneurs and startup founders qualify for NIW, or is it mainly for researchers and scientists?
No, both the entrepreneurs the founders and the researcher and scientists, both groups can qualify for NRW as long as they can fulfill the legal requirements, meaning their proposed endeavor should be of national importance, meaning it should be able to create jobs, helping industries, etc. And they should also pass the threshold requirement. But researchers, scientists, typically they already have a master's degree or a PhD. In terms of entrepreneur or founders, that might be a challenge, but if you are seriously considering that route, NRW route, you should talk to an immigration attorney who can look into it and provide you a few other options also.
All right. Katarina is asking, what happens if I change employers while my green card case is pending?
So the answer depends upon at what stage of green card you are at. If the I-140 is not approved yet, meaning the immigrant petition is not approved yet, and you are changing employer, then the employer might withdraw the I-140 petition. However, when you have already filed your I-485 green card application based on an approved I-140, and 180 days have already passed since the filing of I-485, if you change the employer at that stage, then under the provisions of AC-21, you can do it by filing what is called I-45 Supplement J. So the bottom line is the answer to this question would depend upon at what stage of employer-based green card application you are changing the employer.
All right. All right. Thank you so much to everyone who joined us for this special edition webinar. And thank you, Attorney Lal, for sharing your knowledge and practical guidance with us today.
Thank you for having me. Have a good day.
Everyone else, you can always visit immigrationquestion.com to ask immigration related questions, stay informed about policy updates, and register for upcoming live events. And if you missed any part of today's important discussion with Attorney Lal, the replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Wednesday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye bye.